Confidentiality of information. Confidentiality of information. 34 CFR Section 300.610. The USP staff and LEAs take appropriate steps to ensure the protection of the confidentiality of any personally identifiable data, information, and records collected or maintained by the USP staff and LEAs pursuant to the IDEA. Definitions. 34 CFR Section 300.611. Destruction means physical destruction or removal of personal identifiers from information so that the information is no longer personally identifiable. Education records mean the type of records covered under the definition of education records in 34 CFR Section 99, implementing regulations of the Family Educational Rights and Privacy Act of 1974, 20 U.S.C. Section 1232 grams. FERPA. Participating agency means any agency or institution that collects, maintains, or uses personally identifiable information, or from which information is obtained, under the IDEA. Personally identifiable. 34 CFR Section 300.32. Personally identifiable information means information which must be maintained securely and which includes 1. The name of the student's parent, or other family member. 2. The address of the student. 3. A personal identifier, such as the student's social security number or student number. 4. A list of personal characteristics or other information that would make it possible to identify the student with reasonable certainty. Notice to parents or adult student. 34 CFR Section 300.612. The USP and LEA must give notice that is adequate to fully inform parents or adult students, including 1. A description of the extent that the notice is given in the native languages of the various population groups in the state. 2. A description of the students on whom personally identifiable information is maintained, the types of information sought, the methods the USP intends to use in gathering the information, including sources from whom information is gathered, and the uses to be made of the information. 3. A summary of the policies and procedures that LEAs must follow regarding storage, disclosure to third parties, retention, and destruction of personally identifiable information, and 4. A description of all of the rights of parents and students regarding this information, including the rights under FERPA. Before any major identification, location, or evaluation activity, the notice must be published or announced in newspapers, or other media, or both, with circulation adequate to notify parents or adult students throughout the state and LEAs of the activity. Access rights. 34 CFR Section 300.613, 34 CFR Section 99.10. Each LEA must permit parents or adult students to inspect, staff and review any education records relating to their students that are collected, maintained, or used by the LEA. The LEA must comply with the request without unnecessary delay and before any meeting regarding an IEP, or any hearing or resolution session, and in no case more than 45 calendar days after the request has been made. The right to inspect and review education records under this section includes 1. The right to a response from the LEA to reasonable requests for explanations and interpretations of the records. 2. The right to request that the LEA provide copies of the records containing the information if failure to provide those copies would effectively prevent the parent or adult student from exercising the right to inspect and review the records, and 3. The right to have a representative of the parent or adult student inspect and review the records. And LEA may presume that the parent or adult student has authority to inspect and review records relating to his or her student unless the LEA has been advised that the parent does not have the authority under applicable state law governing such matters as guardianship, separation, and divorce. Record of access. 34 CFR Section 300.614. Each LEA must keep a record of parties obtaining access to education records collected, maintained, or used under the IDEA and used special education rules, except access by parents or adult students and authorized employees of the LEA, including the name of the party, the date access was given, and the purpose for which the party is authorized to use the records. Records on more than one student. 34 CFR Section 300.615. If any education record includes information on more than one student, the parents of those students or the adult students have the right to inspect and review only the information relating to their student or to be informed of that specific information. List of types and locations of information. 34 CFR Section 300.616. On request, the LEA must provide parents or adult students with a list of the types and locations of education records collected, maintained, or used by the LEA. Fees. 34 CFR Section 300.617. The USP staff in each LE may charge a fee for copies of records that are made for parents or adult students under the IDEA if the fee does not effectively prevent the parents or adult students from exercising their right to inspect and review those records. The USP staff in an LE may not charge a fee to search for or to retrieve information under the IDEA. Amendment of records at parents' request. 34 CFR Section 300.618. 34 CFR Section 99.20. A parent or adult student who believes that information in the education records collected, maintained, or used under the IDEA or used special education rules is inaccurate or misleading or violates the privacy or other rights of the student may request the LE that maintains the information to amend the information. The LE must decide whether to amend the information in accordance with the request within a reasonable period of time of receipt of the request. If the LE decides to refuse to amend the information in accordance with the request, it must inform the parent or adult student of the refusal and advise the parents or adult student of the right to a hearing on the matter. Opportunity for a hearing. 34 CFR Section 300.619, 34 CFR Section 99.21. The LE must, on request, provide an opportunity for a hearing to challenge information in education records to ensure that it is not inaccurate, misleading, or otherwise in violation of the privacy or other rights of the student. This hearing is not an IDEA due process complaint/hearing. Result of hearing. 34 CFR Section 300.620. 34 CFR Section 99.21. If, as a result of the hearing, the LE decides that the information is inaccurate, misleading, or otherwise in violation of the privacy or other rights of the student, it must amend the information accordingly and so inform the parents or adult student in writing. If, as a result of the hearing, the LE decides that the information is not inaccurate, misleading, or otherwise in violation of the privacy or other rights of the student, it must inform the parents or adult student of the right to place in the records it maintains on the student a statement commenting on the information or setting forth any reasons for disagreeing with the decision of the LE. Any explanation placed in the records of the student under this section must 1. Be maintained by the LE as part of the records of the student as long as the record or contested portion is maintained by the LE, and 2. If the records of the student or the contested portion is disclosed by the LE to any party, the explanation must also be disclosed to the party. Hearing procedures. 34 CFR Section 300.621. A hearing that challenges education records must be conducted according to the procedures under 34 CFR Section 99.22 as described below. At a minimum, the LE's hearing procedures must adhere to the following requirements. 1. The hearing shall be held within a reasonable period of time after the LE receives the request, and the parents of the student or adult student shall be given notice of the date, place, and time reasonably in advance of the hearing. 2. The hearing may be conducted by any party, including an official of the LE who does not have a direct interest in the outcome of the hearing. 3. The parents of the student or adult student shall be afforded a full and fair opportunity to present evidence relevant to the issues raised and may be assisted or be represented by individuals of his or her choice at his or her own expense, including an attorney. 4. The LE shall make its decision in writing within a reasonable period of time after the conclusion of the hearing. 5. The decision of the LE shall be based solely upon the evidence presented at the hearing and shall include a summary of the evidence and the reasons for the decision. Consent. 34 CFR Section 300.622. Except as to disclosures addressed in referral to an action by law enforcement and judicial authorities for which parental consent is not required by 34 CFR Section 99. Parental or adult student consent must be obtained before personally identifiable information is disclosed to anyone other than officials of participating agencies collecting or using the information under the IDEA or used special education rules, or used for any purpose other than meeting a requirement of the IDEA or used special education rules. And LE may not release information from education records to participating agencies without parental or adult student consent unless authorized to do so by 34 CFR Section 99.31 and Section 99.34, FERPA. 1. Regulation 34 CFR Section 99.31 allows an LE to disclose personally identifiable information from the education records of a student without the written consent of the parents of the student or the adult student if the disclosure is a. to the other school officials, including teachers within the LE who have been determined by the LE to have legitimate educational interests, b. to officials of another school or school site in which the student seeks or intends to enroll, subject to the requirements set forth in 34 CFR Section 99.34, below. 2. Regulation 34 CFR Section 99.34 requires that in transferring the education records of a student pursuant to 34 CFR Section 99.34 above shall make a reasonable attempt to notify the parent of the student or adult student of the transfer of the records at the last known address of the parent or adult student, except that the LEA does not have to provide any further notice of the transfer of records when a. the transfer is initiated by the parents or adult student at the sending LEA. b. the LEA includes in its annual notice of procedural safeguards, that it is the policy of the LEA to forward education records on request to a school in which the student seeks or intends to enroll. And LEA receiving personally identifiable information from another educational agency or institution may make further disclosure of the information on behalf of the LEA without the prior written consent of the parents or adult student if the conditions of 34 CFR Section 99.31 and Section 99.34 noted above are met, and if the educational agency informs the party to whom disclosure is made of these requirements. If the parents or adult student refuses consent for the release of personally identifiable information to a third party, then that party may proceed with statutory procedures in an effort to obtain the desired information. Note, as authorized in 34 CFR Section 99.31, FERPA, Utah LEAs include in the annual procedural safeguards notice that it is their policy to forward educational records of a student with disabilities without parental or adult student consent or notice to officials of another school or school district in which a student seeks or intends to enroll. Safeguards. 34 CFR Section 300.623. Each LEA must protect the confidentiality of personally identifiable information at the collection, storage, disclosure, and destruction stages. One official at each LEA must assume responsibility for ensuring the confidentiality of any personally identifiable information. All persons collecting or using personally identifiable information must receive training or instruction regarding the state's policies and procedures in this section and 34 CFR Section 99. Each LEA must maintain, for public inspection, a current listing of the names and positions of those employees within the LEA who may have access to personally identifiable information for students with disabilities. Destruction of information. 34 CFR Section 300.624. The LEA must inform parents or adult students when personally identifiable information collected, maintained, or used under the IDEA and used special education rules is no longer needed to provide educational services to the student. The information no longer needed must be destroyed at the request of the parents or adult student. However, a permanent record of the student's name, address, phone number, his/her grades, attendance record, classes attended, grade level completed, and year completed may be maintained without time limitation. Each student's records may be considered no longer needed to provide educational services and may be destroyed 3 years after the student graduates or 3 years after the student turns 22 under IDEA. Medicaid requires that records be maintained for at least 5 years after the provision of services. Transfer of parental rights at age of majority. 34 CFR Section 300.520. When a student with a disability reaches the age of majority under state law, i.e., age 18, that applies to all students, except for a student with a disability who has been determined to be incompetent under state law, or the student with a disability marries or becomes emancipated. 1. The LEA must provide any notice required by the IDEA to both the individual and the parents, and 2. All other rights accorded to parents under the IDEA transfer to the student. 3. All rights accorded to parents under the IDEA transfer to students who are incarcerated in an adult or juvenile, state or local correctional institution, and 4. Whenever a state transfers rights, the LEA must notify the individual and the parents of the transfer of rights within a reasonable time frame. Students' rights. 34 CFR Section 300.625. The rights of privacy afforded to parents are transferred to the student who reaches the age of 18, provided the student has not been declared incompetent by a court order or the student has married or become emancipated. Under the regulations for FERPA at 34 CFR Section 99.5a, the rights of parents regarding education records are transferred to the student at age 18, providing the student has not been declared incompetent by a court order or the student has married or become emancipated. Because the rights accorded to parents under the IDEA are transferred to a student who reaches the age of 18, providing the student has not been declared incompetent by a court order or the student has married or become emancipated, the rights regarding educational records must also be transferred to the student. However, the LEA must provide any notice required under Section 615 of the IDEA to the student and the parents. 615 of the IDEA to the student and the parents. 615 of the